On June 27, 2025, a date circled on calendars across the nation, the Supreme Court finally issued its long-awaited decision in Trump v. Casa Inc., a case that had captivated the country. But the ruling wasn't the sweeping declaration on birthright citizenship that many legal experts and citizens alike had anticipated. It was a surprise, to say the least. The court notably avoided deciding the core issue, whether birthright citizenship, as enshrined in the 14th Amendment, definitively applies to children born in the United States to parents who are undocumented immigrants. A question with profound implications for millions. That fundamental question, the heart of the matter, remains unresolved, leaving a cloud of uncertainty hanging over the issue. Instead, in a 6-3 decision that revealed a clear division among the justices, the court addressed a different, though related, aspect of legal procedure. The justices ruled that lower federal courts will now be significantly restricted in their ability to issue nationwide injunctions. These are the powerful orders that have, in the past, effectively blocked federal policies from being implemented across the entire United States. Now, under this new precedent, a single district judge's power is curtailed. They can only block a policy's application for the specific plaintiffs involved in the case before them, and crucially, not for everyone else in the country. This fundamental change means that federal policies could now be legal and enforceable in some states, while simultaneously being blocked and unenforceable in others, creating a divided legal landscape. The result is a patchwork of rights and regulations varying from state to state. The ruling represents a significant shift in power, moving away from the possibility of broad, immediate relief, and instead pushing legal challenges toward fragmented state-by-state legal battles fought in numerous courthouses across the nation. So, the overarching fight over birthright citizenship continues, its ultimate resolution still uncertain. But now, that fight will unfold on a more complicated and decidedly uneven playing field, state by state. To grasp the anxiety this ruling stirs within the Black community and beyond, we need to understand the historical context. The implications of this decision are far-reaching, and the unease is palpable. We must remember why the 14th Amendment exists in the first place. Its creation was not arbitrary, it was born out of a specific need to correct a grave injustice. Its citizenship clause was a direct response, a deliberate and forceful rebuttal to the Dred Scott decision, a dark stain on American legal history. This infamous ruling denied Black people citizenship, stripping them of their fundamental rights and dignity. It not only perpetuated injustice but also set the stage for the Civil War, a conflict fought over the very soul of the nation. The 14th Amendment, ratified in 1868 during the Reconstruction era, promised, unequivocally, that all persons born in the U.S. are citizens, a bedrock principle of American identity. This promise was made especially to the formerly enslaved and their descendants, ensuring their rightful place in the nation they helped build. The Supreme Court's recent decision, while concerning, does not directly touch this core promise of birthright citizenship. Black American citizenship, firmly rooted in the 14th Amendment, is not in question in this particular case. The real concern, however, is the potential weakening of legal tools and precedents, tools that are essential to enforce the amendment's broader guarantees and protections for all citizens. These guarantees include due process and equal protection under the law, cornerstones of American justice. When those tools are limited or eroded, when access to justice is constrained, everyone's rights, regardless of race or background, become more vulnerable to infringement and abuse. The fundamental promise of the 14th Amendment still stands as a beacon of hope and equality, but the means to effectively defend and uphold that promise are now, undeniably, more fragile and require vigilant protection. Ending nationwide injunctions is a seismic shift in civil rights protection. For decades, these injunctions let a single court halt harmful federal policies everywhere, providing immediate relief. Now, legal challenges must be fought district by district, creating a patchwork of rights. Marginalized communities, often targets of discriminatory policies, will face greater hurdles and delays. Without nationwide injunctions, the government can enforce policies in some places while challenges drag on elsewhere. Class action lawsuits may help, but they're slow and complex. The result? A slower, fragmented system, less able to protect people from widespread harm. Equal justice under law now feels more distant and uneven. America's civil rights battles, a long and arduous journey, have always been about overcoming local injustice, fighting against discriminatory practices that varied from town to town, county to county, and enforcing national standards, ensuring that fundamental rights are protected for all citizens, regardless of where they reside. Before the 1960s, rights depended on geography, creating a patchwork of inequality across the nation. Federal intervention and nationwide court orders changed that, leveling the playing field and establishing a baseline of rights for everyone. Fragmented rights are unequal rights. A system where some have more protections than others is inherently unjust. The civil rights movement's power was in making rights national, ensuring that all Americans were treated equally under the law. Limiting nationwide injunctions, a tool used to enforce these national standards, risks returning to a system where rights depend on where you live, undermining decades of progress. This weakens a key safeguard used to protect voting rights, housing, and more, leaving vulnerable populations at risk of discrimination. Now, advocates must fight the same battles repeatedly, expending valuable resources and energy to achieve the same result in different jurisdictions, with slower, less certain results, creating a climate of legal uncertainty and delaying justice for those who need it most. The burden shifts to the Supreme Court, placing immense pressure on the highest court in the land, which hears few cases and takes years to decide, further delaying justice and creating a backlog of unresolved legal challenges. The danger: two tiers of rights, one for those in states with strong protections, and another for those in states with weaker ones, echoing a past when justice depended on your zip code, a dark chapter in American history we must never repeat. Despite the court's decision, birthright citizenship for Black Americans remains secure, a right rooted in the 14th Amendment and the nation's post-Civil War promise. But the legal landscape for defending civil rights is shifting. Without nationwide injunctions, legal battles will be longer, costlier, and more complex. Advocacy groups must adapt, using new strategies to protect rights on a national scale. The unresolved question of birthright citizenship for children of undocumented immigrants will return to the court, testing America's commitment to inclusion. Our own citizenship is safe, but the fight for equal justice continues. Defending the 14th Amendment's promise means ensuring our legal system can protect everyone, everywhere,